Hello everyone. This presentation is brought to you by Synergy Business Advisory Group, Noida, a multi-disciplinary advisory firm providing business advisory services, including CFO support, income tax, insolvency, PMLA, POFE, real estate and commercial legal advisory. One of the most powerful tools under the Insolvency and Bankruptcy Code is the power to avoid certain past avoidable transactions. But when does a transaction become avoidable? The Supreme Court answered this question with clarity in Anuj Jan IRP for Jaypee Infratech Limited versus Axis Bank Limited. This judgment has become the starting point of every discussion on preferential and undervalued transactions under the IBC. Factual background: Jaypee Infratech Limited, commonly known as JIL, entered insolvency. Before CRP began, JIL had created mortgage over its prime land parcels and assets in favor of several banks. These banks had not lent any money to JIL. The loan were advanced to Jayaprakash Associates Limited, the holding company. JIL merely acted as a third-party security provider. When insolvency proceedings commenced, the IRP Mr. Anuj Jan challenged these transactions as preferentials, undervalued and fraudulent under the IBC. The issues before the Supreme Court were: the Supreme Court examined three critical questions. The first question was whether mortgages and securities created by JIL to secure loans taken by its holding company, that is Jayaprakash Associates Limited, could be classified as preferential transactions under Section 43 of the IBC. A preferential transaction occurs when a corporate debtor enters into a transaction that gives certain creditors a better position than others, reducing the value of insolvency estate available to all creditors. In this case, JIL used its assets to benefit select banks that were creditors to JIL, not JIL itself, thereby creating an advantage for certain parties. The court had to determine whether third-party securities could fall under the scope of preferential transactions even though the loan was not owed by JIL. The Supreme Court clarified that using the corporate debtors' assets for the benefit of group company lenders, which adversely affects the insolvency estate, constitute a preferential transaction. Financial creditors' status without disbursement. The second issue was whether lenders who received security from JIL but did not actually disburse any funds to JIL could be considered financial creditors under the IBC. Under Section 5, subsection 7 of the IBC, a financial creditor is someone to whom the corporate debtor owes a financial debt, usually arising from actual fund disbursement or loan. In this case, the lender did not advance any funds to JIL. The funds were provided to JAL. The Supreme Court held that a security interest without actual disbursement does not create a financial debt, and therefore these lenders cannot be considered financial creditors and cannot participate in the COC, that is Committee of Creditors. This ensures that the insolvency process remains fair and equitable, preventing undue advantage to select lenders. The third issue was whether these transactions could be considered in the ordinary course of business under Section 43, subsection 3 of the IBC. The ordinary course of business exception protects transactions that are routine and normal commercial activities of a company. The court examined whether providing securities for a holding company's loan was part of JIL's normal business operations. The court held that this was commercially unusual, not a routine business activity, and was intended to benefit select creditors and therefore could not be protected under Section 43, subsection 3. Final decision. The Supreme Court set aside the mortgages created by GIL in favor of the banks and allowed the IRP's avoidance applications. By doing so, the court restored the assets to the insolvency estate of GIL, ensuring that the corporate debtor property was protected for the benefit of all creditors. This decision reinforced the principle that the preferential transactions favoring select parties can be voided under the IBC. The judgment clarified that group company arrangements cannot dilute IBC protection. This is CA and insolvency professional Praveen Agrawal signing off. Looking forward to seeing you in the next video. Thank you.